Hi, I'm Debbie Moraes. Welcome to Legal Matters. This is the program that has been designed to address some of the critical, sometimes contentious, always timely issues facing consumers and businesses today. It's legal information, it's practical solutions, and it's straight talk about a wide variety of topics. Most recently, family law, finance, Social Security, workers' compensation, personal injury, and more. In our last program, we were talking about the actual process of personal injury and workers' compensation cases, and we were discussing a little bit the differences between them, and more specifically, the roles that our attorneys play in them. Once again, we are going to pick up where we left off because we were just broaching the topic of how one addresses those financial settlements. So once again, we want to welcome David Bazar and Bob Audette, partners from Audette Bazar Grasso law firm in East Providence, and their special guest, our guest, we want to welcome Chris Larred. He's consultant from the East Providence office of EPS Settlements Group. Welcome.
Thank you for having me.
We're happy to have you, and we're happy to have you because you specifically address these financial issues. So, when we were talking about personal injury and workers' compensation and that process, now we have you in the mix here. So if you would, please explain your individual roles. I think maybe we'll toss this to our lawyers first and then ask you what you do and how it works together.
Sounds fair.
Well, why don't we bring Chris up to date with what we spoke about a little bit last time, which was really catastrophic injuries. Mm-hmm. We've talked before about how you handle a routine personal injury case in workers' compensation in the past. We were dealing with catastrophic injuries, and we had talked about developing a life care plan that would set out what somebody might need to care for them for the rest of their lives. And that brings us to you and how you might help us decide how to fund those types of things and what the advantages are of a structured settlement, so to speak.
Great.
Thanks for that assist.
Well, a structured settlement is basically a stream of periodic payments. One can take a settlement as a lump sum, but they could also take it in a scheduled series of payments into the future. And structured settlements have been around about 30, 40 years. My company did the very first one back in the late 70s. The benefits to a structured settlement, similar to taking a lump sum, one gets the money all at once, it's tax-free to them. So one of the very unique benefits is that the interest earned on a structured settlement is also tax-free and not reportable. So these are huge financial benefits to the injured party. When we deal with a life care plan or a catastrophically injured person that probably can't return to work, it's important that they have the ability to know that money is coming in. Structured settlement payments are extremely secure payments coming from bond portfolios and life insurance annuities. Okay? So we have the ability to pay somebody so that their funds never run out, that we're able to transfer what's called mortality risk over to a life insurance company and say, pay this person $5,000 a month for the rest of their life, make it increase at 3% per year. This way they have no further need for worrying about, will the stock market help them out? Will my savings last? They don't have to worry about it lasting. We're guaranteeing that in a contract.
Well, we've got some of the pros there. I think we should go through some of the cons, but I think I want to go back for a moment based on what we were talking about in our earlier segment, and you specialize in some of those workers' compensation and personal injury cases, Bob. At what point do you realize that you need to or are wanting to bring in someone who handles settlements? How do you have that play out in your office?
Oftentimes it depends on the amount of the settlement. In smaller cases, like David said, the routine run-of-the-mill cases, there's usually not enough money to get someone like Chris or his company involved because the value just isn't there.
What is that? Is there a bottom line?
Not really a cutoff, no.
Okay.
The other place that Chris's company does get involved, though, is in smaller cases for minors, because in Rhode Island those payments cannot go directly to a minor. So you have a child that's bit by a dog or injured in a car accident, and then they're getting a payout for their damages. They usually can't take that money until they become an adult. So oftentimes structured settlement annuities have to be done in those cases so the money can be safe and held for the child until they reach majority. So that's an example of where Chris would get involved in a smaller case. But normally he'd be involved in more significant cases where you're thinking about lost lifetime income perhaps, or or medical care for life, as David was talking about earlier.
Now, if we were going to stay with that issue about the guardian, which I understand now is that's one of the, or having a young person who has a settlement, why wouldn't that automatically go to the parent to oversee it or put it in a trust and not even begin to deal with the settlement? Or is it just not about the amount, it's just a matter of how it's handled? How do you deal with
I
that?
guess there's a few reasons. The judges actually have become much more attuned to the value of a structured settlement. So the structured settlement itself adds value to this. When we first started, Bob and I, and we'd go in on what you would call a friendly suit where a judge would have to approve any settlement for a minor child over $10,000. The structured business was just beginning. As Chris said, it was probably in its infancy when Bob and I started. We may have started while it was in its gestation period. In any event, what judges are looking at when they approve a settlement for a minor is, first of all, the parents understand that if they are getting any of the money, it's for the benefit of the child. By putting it in a structure, it takes any temptation away from that parent to take that minor's money before the child reaches 18. And when we first began doing these, it's interesting, there was one judge that would sit on this calendar who would always want the money made available to the child when the child turned 18, which could be problematic because once you put money into a structure and you want the ability for that money to grow, beyond that, you could not break the structure early. It's just the way they're set up. So we had to educate the judge on the benefits of letting this money grow for the benefit of the child. Maybe get some at 18, but spread it out over the course of time. And most judges now are comfortable with allowing that money to grow tax-free, as Chris said, for the benefit of the child.
So when that amount is decided upon, do you work with the judge? Do you bring in someone like Chris to determine how that should be parceled out? How does that happen?
Yeah, Bob.
In the case of a minor, the court will appoint a guardian ad litem. That will be a separate attorney who is not directly involved in the case, who will come in and meet with the family and the minor to make sure that the gross amount of the settlement is appropriate for the child. The next step is then you would bring in someone like Chris to come in and say, okay, how are we holding this money? For how long are we holding the money? And what's the payout going to be for the child? Is it going to be at 18? Is it going to be at 21 when they graduate or 22 when they graduate college? Are we going to pay it in installments once they get older? So perhaps when if that child makes a mistake with the first installment and that money goes away, that they have more coming behind it. So that's the process. And that's a really interesting and helpful process for families and these children to make sure they're taken care of.
So Chris, then you would work with this set of lawyers as well as the guardian ad litem to decide?
I've been called into cases for minors specifically by
Yes.
the attorneys, by the insurance companies paying the claims, by the guardian ad litems. Any one of those parties will bring us in. And the state cannot assume that you or I or these fellows are good parents. They treat everyone the same, protect the child's money.
Right. And what Chris will then do is he'll come into the meeting and listen to the parents, the child, the lawyers as they talk about what the needs of the child are. And he'll then try to help give some ideas as how you might be able to structure this to take into consideration that individual's needs.
Typically, a payment stream for a child, the first thing everyone thinks of is a 4 or 5 year college fund. If there's a few more dollars available, maybe there's a monthly stipend that we would pay out. Depending on the injury and the dollar amount, maybe payments do need to be made prior to age 18 for scar revision, for prosthesis, or those get into the catastrophic injuries, but money isn't excluded from being paid out prior to majority, but it can be and typically is. We typically, for kids, will pay out to about age 30, just trying to keep it short, the money for them, again, unless it's catastrophic where we're looking at lifetime. But commonly I'll do an education fund. Whether they go to school or not, the payment is made. These payments are guaranteed to be made. Even if the child is deceased, the payments will be made to the estate. But we'll make lump sums at 25 or 30. It'd be great to know that you could buy a house when you turn 30, but also have an educational payment made for you. And the interest rates that we pay are subject to the relative term that we have. If I've got 5 years or 15 years, the longer the carrier holds the funds, the more that they're going to be getting in terms of a payment down the road.
How does